Okay. We're back on the record in cause number 323-736. And I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Ms. Babineau, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And is this are these your initials on the line that says, I waive my right to an attorney and I desire to represent myself?
Yes, sir.
And also I have before me a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is that your signature above the line that's titled Defendant? You have to speak up?
Yes, sir.
Okay. Now, Ms. Babineau, prior to signing and initialing these documents that I just mentioned, did you have an opportunity to read the documents?
Yes, sir.
And did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. State, I have before me State's Exhibit number 1. State, like the office State's 1?
Yes, Your Honor.
Ms. Babineau, the state is offering State's Exhibit number 1 to be used as evidence against you in your case. Now, State's Exhibit number 1 is the first document that you acknowledge. And it's the same document that have your initials on page 2 and your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
No objection. State's Exhibit number 1 will be admitted. Ms. Babineau, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Ms. Babineau, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers was freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
It's a 6-month deferred adjudicated probation.
Okay, Ms. Babineau, the state is offering in your case that you serve 6 months deferred adjudicated probation,
It's a, I'm sorry, Your Honor, a $100 fine
$100 fine,
and no community service.
no community service.
Yes,
All right. Okay. Now, Ms. Babineau, the state is offering that you serve 6 months deferred adjudicated probation in your case. During that 6-month period, you'll be required to pay a fine of $100 plus court costs of $337. The total fine and court costs comes to a total of $437. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. The total monthly installments come to a total of $165 per month. Will you be able to pay the $165 each month?
Yes, sir.
You will also be required, well, you will not be required to perform any community service because the court, not the court, but the state is waiving the community service in this case. And you will also be required to adhere to the other standard terms and conditions of probation. Now, Ms. Babineau, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Ms. Babineau, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Babineau, if you successfully complete the probationary period, this case will be dismissed. It will not appear in your record as a conviction, and you may qualify for a non-disclosure. Ms. Babineau, you can talk to an attorney about your non-disclosure. Ms. Babineau, please stand on the X
Okay.
to your left. You're gonna follow the directions of the clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day.
Thank you.
You're welcome.
Go ahead and get your right thumbprint on that blue button. We're good to go. This address that I'm gonna highlight in yellow as soon as you leave here, and I'll go over your probation. Okay. Oh. Yeah, you're good. Thank you so much. Thank you.
We're in session in cause number 328372. The case is styled the state of Texas versus Alfonso Maradiaga. Mr. Maradiaga, would you please come forward? Mr. Gilthorpe?
Which one, Judge?
Mr. Maradiaga?
Maradiaga?
Yes,
Yes.
Maradiaga.
Maradiaga.
Maradiaga. And Mr. Gilthorpe, does Mr. Maradiaga speaks English?
He does not.
And so you're gonna interpret?
I will, Your Honor.
Would you please raise your right hand? Mr. Gilthorpe, do you swear to interpret English to Spanish and Spanish to English?
Yes.
So help you God?
Yes, Judge.
All right, you may put your hand down. The case is styled the state of Texas versus Alfonso Maradiaga. Is that your full name?
Yes.
Okay. How are you doing?
Yeah. Well,
Okay. Okay, Mr. Maradiaga, I have before me an information that alleges that on or about September 24th of 2020, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Do you understand what you have been charged with?
yes.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you're guilty?
Yes.
Now, there are set of initials at the bottom of this document. Below the paragraph that is titled citizenship. And I will read this paragraph, and it reads, if you are not a U.S. citizen, a plea of guilty or nolo contendere may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Maradiaga, do you understand?
Yes.
And do you still want to go forward with your plea?
Yes.
And did your attorney explain this to you?
Yes.
Okay. On page 2 of this same document, there are a set of initials AM on the line that's titled guilty. Are these your initials?
Yes.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes.
And on the next document, which is a trial court certification of defendant's right of appeal, do you recognize this document?
Yes.
Is this your signature above the line that's titled defendant?
Yes.
There are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes.
The second box states that you're waiving your right to an appeal. Do you understand that?
Yes.
Do you have your discovery certification?
Oh, yes, I have.
Okay. I have before me a document that is titled discovery certification. Do you recognize this document?
Yes.
Is this your signature above the line that's titled defendant?
Yes.
Prior to signing and initialing these documents, did your attorney go over these documents with you?
Yes,
And did you read and understand everything in these documents?
yes,
And is everything in these documents true and correct to the best of your knowledge?
yes,
Okay. Is, Mr. Maraga, are you a US citizen?
no,
What country are you from?
Honduras.
Okay, they're not on the list. Okay. Now, Mr. Radiaga, do this, prior to signing and initialing these documents, did your attorney go over these documents with you in Spanish?
Yes,
And did you understand everything that he went over?
yes, yes,
And is everything in these documents true and correct to the best of your knowledge?
yes,
State, I have before me state's exhibit number 1. State, you like to offer states 1?
Yes, Your Honor.
Any objection?
no, Your Honor.
No objection. State's exhibit number 1 will be admitted. Mr. Gilthorpe, you've advised in counsel, Mr. Mariaga. Is there any evidence that he is mentally incompetent to stand trial?
No, Your
Mr. Mariaga, your attorney has advised and counseled you. Are you satisfied with his representation?
Honor. Yes,
Has he provided full, effective, and competent legal representation?
yes,
Okay. Mr. Madariaga, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your pleas and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
180 days county jail. Probated over 18 months. $1,000 fine. 60 hours community service. DWI education course. Drug and alcohol assessment. And Ignition Airlines.
Mariaga, the state is offering that you serve 180 days in jail, but you would not have to serve any time in jail because you'll be placed on probation for 18 months. During the 18-month probationary period, you'll be required to pay a fine of $1,000 plus court costs of $422. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You will be also required to pay a Jefferson County DWI education class and initial evaluation fee of $125. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments for this case is $160 per month. Mr. Mariaga, would you be able to pay the $160 per month?
yes,
Okay. You will also be required to perform 60 hours of community service, attend a DWI education class, and have a drug and alcohol assessment. You will also be required to install the DWI interlock device on any vehicle that you own or operate. And you would have to follow the standard terms and conditions of your probation. Do you understand?
Yes.
Do you think that the state's offer is fair and just?
Yes.
And do you accept the state's offer?
Yes.
Mr. Madaraga, I will follow your plea bargain agreement that you have entered into with the state. Stand on the X next to your attorney and follow the directions of our clerk.
Mr. Mardiaga, I'm gonna need your right thumbprint on that blue light. Lift your finger for me real quick. Now try it again, please. Lift it for me again. There we go. Mardiaga,
Sí, no se ve, pero ahí se lo ve.
Mr.
Looks like we should stop at that 1:30.
William Cardenas? Okay, we're in session and cause number 329. Well, Mr. Gilthorpe, does Mr. Cardenas speak English?
No, Judge.
He speaks Spanish?
Yes.
Okay. Mr. Gilthorpe, you have already been sworn in to interpret Spanish to English, English to Spanish. Mr. Cardenas, would you please raise your right hand? Mr. Cardenas, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Mr. Cardenas, you may put your hand down. How are you doing?
Well,
That's good. Mr. Cardenas, I have before me information that alleges that on or about November 8th of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more while you were operating a motor vehicle in a public place in Jefferson County, Texas. Mr. Cardenas, Do you understand what you've been charged with?
Yes.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty?
Yes.
Mr. Cardenas, I have before me a document that is titled "The Misdemeanor Plea Admonishments," also labeled State's Exhibit 1. Do you recognize this document?
Yes.
On page 2 of this same document, there are a set of initials on the line next to a box that's checked guilty. Did you place your initials on this document?
Yes.
And on page 3 of the same document, there's a signature above the line that's titled defendant. Is that your signature?
Yes.
And on the next document, which is a trial court certification, there, do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
There are two boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes.
The second box states that you're waiving, which means you're giving up your right to an appeal. Do you understand that?
Yes.
You have his discovery certification.
Please, Judge.
I also have before me a document that is titled Discovery Certification. Do you recognize this document? Is
Yes.
this your signature on the line that says defendant?
Yes.
Before you sign and initial these documents, did your attorney go over these documents with you in Spanish?
Yes.
And did you understand everything that he went over?
Yes.
Mr. Cardenas, are you a US citizen?
No.
What country are you from?
Honduras.
Honduras? Okay. Now, Mr. Cardenas, are these your initials next to the paragraph that's titled citizenship? And
Yes.
I will go over this paragraph with you. That's titled citizenship. If you're not a US citizen, a plea of guilty or nolo contendere may result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Do you understand that?
Yes.
And did your attorney explain this to you?
Yes.
And did you understand what he explained to you?
Yes.
Do you still want to go forward with your plea of guilty?
Yes.
Now, did your attorney go over these documents that have just went over? Did he go over these documents in Spanish? And did you understand everything that he went over? And is
Yes.
everything in these documents true and correct to the best of your knowledge?
Yes.
State, I have before me State's Exhibit Number 1. State, you like to offer State's 1?
Yes, Your Honor.
No objection.
No objection. State's Exhibit Number 1 will be admitted. Mr. Gilthorpe, you advised and counseled Mr. Cardenas. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Cardenas, Mr. Gilthorpe has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes.
Mr. Cardenas, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. And I will also find that your pleas and waivers was freely and voluntarily given. And I will also find that there's sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
Yes, Your Honor.
What is that agreement?
It's 180 days county jail, probated over 1 year. The $1,000 fine, 60 hours community service, a DWI education course, drug and alcohol assessment, and interloan.
Mr. Cardenas, the state is offering that you serve 180 days in the Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail because you will be on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $1,000 and court costs of $422, which comes to a total of fine and court costs of $1,422. You'll be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You will be required to pay Jefferson County DWI education class and initial evaluation fee of $125. Should a further evaluation be needed, you'll be required to pay $50. Now your total monthly installments for this case is $205. Would you be able to pay $205 each month?
Yes.
You will also be required to perform 60 hours of community service, attend a DWI education class, and have a drug and alcohol assessment, install a DWI interlock device on any vehicle that you own or operate, and you would have to adhere to the standard terms and conditions of your probation. Mr. Cardenas, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes.
I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Cardenas, please stand on the X next to your attorney and follow the directions of our clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day.
Can I get your right thumb print on the blue light, please? Thank you. You can move it. Your signature on the signature. All right, and Mr. Gilchrist, can I get your signature? And Mr. Cadenas, can you raise your right hand for me? Do you swear that you've never before been given probation or deferred adjudication? The state or any other state? And you have no other pending charges? You're gonna report to this address that I've highlighted in yellow as soon as you leave here and keep it.
We're in session at cause number 329692 to state the case is styled of State of Texas versus Maria Rosalia Rodriguez Santos. Oh, she does?
Yes.
Ms. Santos, would you please raise your right hand? Ms. Santos, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Santos, you may put your hand down. How are you doing, Ms. Santos?
Okay,
now, Mr. Gilthorpe, did you waive a record
yes.
in
Judge, we do have
this
a record.
case and the previous cases?
Yes,
Okay, now, Ms. Santos, I have before me information that alleges that on or about April 12th of 2021, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated. Ms. Santos, do you understand what you've been charged with?
Yes.
And to this charge, Ms. Santos, how did you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you're guilty?
Yes.
Ms. Santos, I have before me a document that is titled the misdemeanor plea admonishments. And, oops, pull up the wrong one. And, Ms. Santos, do you recognize this document? On page 2 of the same document, Ms. Santos, are these your initials on the line that's titled, was next to a box that's titled guilty? And on page 3 of the same document, is that your signature above the line that's titled defendant?
Yes.
And on the next document, which is trial court certification, the defendant's right of appeal, do you recognize this document? Is this your signature above the line that's titled defendant?
Yes.
There are 2 boxes that are checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes.
The second box states that you're waiving your right to an appeal. Do you understand that? And the next document that I have, do you have, oh, it's a discovery certification. Do you recognize this document? Is this your signature above the line that's titled defendant?
Yes.
Now, prior to signing and initialing these documents that I've just mentioned, did your attorney go over these documents with you?
Yes.
And did you read and understand everything in these documents?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
State, I have before me State's Exhibit number 1. State, you like to offer State's 1?
Yes, Your Honor.
Any objections?
No, Judge.
No objections. State's Exhibit number 1 will be admitted. Mr. Gilthorpe, you've advised and counseled Ms. Santos. Is there any evidence that she's currently mentally incompetent to stand trial?
No, Judge.
Ms. Santos, your attorney, Mr. Gilthorpe, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Santos, now, are you a U.S. citizen?
No.
Okay, Ms. Santos, what country are you from?
I'm from Mexico.
Mexico. Okay, they're not on the list either. Now, Ms. Santos, on State's Exhibit number 1, which is the misdemeanor plea admonishment, there's a paragraph that's titled citizenship. I will go over this paragraph with you. It says, if you're not a U.S. citizen, a plea of guilty or no contendere may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. Do you understand that?
Yes.
And did your attorney go over the citizenship with you?
Yes. Sir.
And do you still want to go forward with your plea?
Yes.
Okay, Mr. Gilthorpe, did you get an initial, that paragraph that says citizenship?
Yeah.
Okay. Now, Ms. Santos, let me go over this here. Ms. Santos, did I ask you whether or not you, did your attorney provide full, effective, and competent representation? And you're satisfied with your attorney? Okay. Now, Ms. Santos, I will accept your plea of guilty. I will find that you're mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
90 days jail, probated over 1 year, $700 fine,
Okay,
40 hours community service, DWI education course, and drug and alcohol assessment.
okay, Ms. Santos, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During the 1-year probationary period, you'll be required to pay a fine of $700 plus court costs of $417. The total amount of the fine and court cost is $1,117. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll be required to pay Jefferson County DWI education class an initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay a fine, you'll be required to pay an additional $50. Now, Ms. Santos, the total amount that you would have to pay per month is $180. Will you be able to pay the $180 each month?
Yes.
Ms. Santos, you'll also be required to perform 40 hours of community service, attend the DWI education class, and have a drug and alcohol assessment. And you also be required to adhere to the other standard terms and conditions of probation. Ms. Santos, do you understand?
Yes.
Do you understand the state's offer?
Yes.
Do you think that the state's offer is fair and just?
Yes.
And do you accept the state's offer?
Yes.
Okay, Ms. Santos, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Santos, stand on the X next to your attorney, and you're gonna follow the directions of the clerk. And once you finish following the clerk's directions, you'll be free to go, and you have a blessed day.
Can I get your Yes, and you have the waiver, so.
Oh, so they were supposed to talk to Ms. Fontenot? Okay, let's do, when we're on record in cause number 329372 and cause number 329374, State of Texas versus Gabriella Fontenot, Gabriella D. Fontenot. How are you doing?
I'm fine.
Okay, now, so just informed that you have a waiver on file stating that you wanted to represent yourself in this case. Is that correct? Have you had an opportunity to talk to the prosecutor in the case?
Yes, sir.
Okay. What we can do is give you well, had you talked to the prosecutors in the past on your case?
Is the gentleman right here, someone like that?
Yes,
Yes, I talked to him last time I came to court.
okay. What, Mr. Daniel Boyd? Do you-
Yes, Your Honor. I have it listed as Miss Maxey's case. I'm not sure. I don't have any notes in there.
Was an offer or anything made to her?
Last time I came, they offered me a year, $700 fine.
Okay, were you accepting that offer or not?
That why not? Because.
No, I didn't say why not.
Oh.
I actually, are you accepting it or rejecting it?
As of today,
Wh-
last time I didn't accept it, no, sir.
Okay, so what do you want to do today?
Get it over with, just take it.
Okay, let me do this here. We're gonna let you. Let's see, we may have to do her. Are you working?
Yes, sir, just started.
You, okay. So we may have to, we have to have you come back after lunch to do the paperwork, because we have something going on right now, okay? So let's do this here. I know he's coming back at 1:30, but he didn't have a trial docket. Because the trial docket went away, but he's coming back at 1:30. That's what he said. Yes, 3, okay. So we'll do yours after his. So just show back up at 1:30 so they can do the paperwork. And then once he finished, then we'll do your case, okay? All right, you have a blessed day. Well, we're gonna have to, Mr. Kimler was here. You say Rife Kimler, I don't see Rife, it says to hire Rife, but apparently there's no letter of representation that he's, so you say you hired Rife? Let's reset him up, 30 days. We're gonna reset your case.
Yes, sir.
And then, if Mr. Kimler's gonna get us a letter of representation.
Okay.
Stand over there on the 4X. You may be seated. We're back in session in clause number 322383. The case is styled the state of Texas versus Benjamin Steele. Let the record reflect that Mr. Benjamin Steele is present with his attorney, Attorney Jansen Bailey. We also have present in the court, Assistant District Attorney, sitting first chair, Ms. Julie Maxey, and we also have sitting second chair with Ms. Julie Maxey, Mr. Daniel Boyd. Let the record also reflect that the jury is now present in the courtroom. State, are you ready?
It's ready, Your Honor.
Defense, are you ready?
This is ready, Your Honor.
Ms. Maxey, would you please read the information?
Yes, Your Honor.
Would y'all please stand?
In the name and by authority of the state of Texas, comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the County Court of Law of Jefferson County, Texas, that in Jefferson County, Texas, Benjamin Steele, hereafter styled the defendant, heretofore on or about February 24th, 2019, did then and there intentionally, knowingly, and recklessly cause bodily injury to another, named Kelsey Lewis, hereafter styled the complainant, by kicking and hitting the complainant's head and body with his feet and hands. And at the time of said assault, complainant was a person with whom the defendant has had a dating relationship against the peace and dignity of the state.
And Mr. Steele, how do you plead?
Not guilty.
Okay, you may sit down, you may be seated. State, would you like to make an opening statement?
Yes, Your Honor.
You may proceed.
Good afternoon, ladies and gentlemen. Thank you for your patience. Thank you for being here today. This case is about an assault that took place back in February of 2019, as you just heard. Took place at the residence of the defendant and the victim, and was his girlfriend at the time. The victim had locked her keys in her car that afternoon, and upon asking for help to get the keys out of the car, the defendant ended up attacking her by pushing her down, kicking her, and hitting her with his hands. Today, you'll hear from the victim in this case. You'll hear her recount the events of that afternoon. You'll hear about the details of what happened. You'll hear about the pain and injuries that she sustained as a result of the events of that time. You'll also see the photographs from what happened that day. You'll see the photographs of the injuries that she sustained, the bruising, the redness, the swelling that resulted from the events in question. Ladies and gentlemen, it was discussed yesterday what a high burden the state has to prove to you. And I know that that's not something that I take lightly, nor do you take lightly. After all the evidence has been heard, all the evidence has been presented, you'll find that the defendant intentionally, knowingly, or recklessly caused bodily injury to Kelsey Lewis. And you'll find that the defendant is guilty of assault. Thank you.
Mr. Bailey, would you like to make an opening statement, or would you like to reserve your opening statement?
Reserve.
Okay. State, are you ready to proceed?
Yes, Your Honor.
Okay, you may call your first witness.
The state called Michelle Seha to the stand. There's no witness.
Your Honor, I'm sorry, but can I verify from my phone?
Yes. You're welcome. Ms. Seha, would you come forward? Ms. Seha, would you please raise your right hand? Ms. Seha, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, Ms. Seha, you may take the witness stand and you can adjust the mic.
Is it C-E-J-A? Yes.
Ms. Maxey, you may proceed.
Thank you, Your Honor. Can you please state your name for the record?
Michelle Seha.
Thank you for being here this afternoon or right around noon, Ms. Seha. How are you employed
I work for Beaumont Police Department.
and what's your job there?
I am a crime scene tech.
Can you describe to the jury a little bit about what your duties are as a crime scene tech?
And depending on the crime scene, I take pictures, possible video, there may be some fingerprinting, and possibly collecting any evidence.
And were you working on the evening of February 24th, 2019?
Yes,
And were you sent out on a call that evening?
yes.
Do you remember where that call was to?
I went to 3895 Belgium.
And when you arrived there, what did you see?
I had to speak with officers on the scene and the complainant. And I was advised of any possible injuries or any pain that she might have felt.
And was that complainant Kelsey Lewis?
Yes,
And what did you do after you spoke with the officers and met with found out about any injuries that might have taken place?
I would talk to the complainant and she would tell me of any injuries she might have, and I would take pictures of those injuries. If she felt any pain, I would take pictures of those areas.
And so did you take pictures that evening?
Yes,
Ms. Seha, I'm showing you what is marked as State's Exhibit 1, 2. Three.
Ms. Maxey,
Oh, may I push?
before you do that, yeah, you have to put your gloves on and then give her some gloves too.
Sorry, Judge.
Ms. Maxey, can I see them first?
I'm gonna let you inspect them. I'm just gonna have her identify them and then I'll wait. Okay, so Ms. Seha, may I approach the witness, Judge?
Yes, you may.
I'm showing you what is marked as State's Exhibit 1, 2, 3, 4, 5, 6, 7, and 8. Would you please have a look at these photographs for me? Recognize the person in those photographs?
yes.
And who is?
I took pictures of Kelsey Lewis.
Okay, and are those photographs, State's Exhibits 1 through 8, fair and accurate depictions of Kelsey Lewis as you observed her?
Yes,
The state would like to tender the exhibits to defense for inspection and offer into evidence, Judge.
No objection, Your Honor.
No objections. States Exhibit 1, 2, 3, 4, 5, 6, 7, and 8 are admitted.
I'm gonna leave these right here, Judge.
You can step this. Set them forward. Step up. Oops.
I'm so sorry, I'm okay. Cool. Okay, pass the witness, Your Honor.
Okay. Mr. Bailey?
I have no questions.
No questions? Okay. Miss Maxey, may this witness be excused?
Yes, Your Honor.
And Mr. Bailey, may this witness?
Yes, Your Honor.
Okay. Miss Seha, you are excused. Thank you for coming here today, and you have a blessed day.
Thank you.
Miss Maxey, you may call your next witness.
Thank you, Your Honor. The state calls Kelsey Lewis to the stand.
Your Honor, one thing before we continue, can I invoke the rule? I know that we don't have a gallery, but I don't know about.
Okay. Ms. Lewis, would you come forward? Ms. Lewis, would you please raise your right hand? Ms. Lewis, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Ms. Lewis, you may put your hand down. Ms. Lewis, oh, before you do that. Okay, now, Ms. Lewis, you may take a seat. And you could adjust the mic. Ms. Maxey, are you ready to proceed?
Yes, Your Honor.
You may proceed.
Thank you. All right, thank you for being here this afternoon. Can you please state your name for the record?
Kelsey Lewis,
And are you employed, Ms. Lewis?
self-employed.
I want to bring you to the events of February 24th, 2019. Do you remember that day? And where were you that day?
In fact, we
Okay.
went out to eat and then we went back to his house.
And where is that house located?
On the Minister.
Is that in Jefferson County, Texas?
Yes.
And so how did you begin that afternoon?
So we went out to eat, and then whenever we got back, he took his dirt bike around the neighborhood, and then whenever he drove it back in, he drove past my leg and he burnt my leg. I did have a hole in the burn.
Let me stop you there. The person you were with, who was that?
Then,
And do you see that person in the courtroom today? And can you please identify him, point him out and identify something he's wearing?
Strictly.
Your Honor, may the record reflect that the witness has identified the defendant?
The record will so reflect.
And so you know the defendant personally, is that correct? How do you know him?
We were together. No,
So you were in a relationship with Mr. Steele? Okay. And how long would you say that relationship lasted?
a little over 3 years.
And did you live together during the time of that relationship? You mentioned you had gone out to eat on February 24th. Were y'all drinking that day?
Yeah, we took, maybe like 2 or 3 shots. We had work the same night, so. Someone bought us shots, actually.
Okay. And were you drunk?
No.
Was the defendant drunk?
No.
So you mentioned that he took up on his dirt bike from the leg of your pants. What happened next?
I went to go get something out of my car. I realized that the keys were locked in. I asked if she could unlock the car because he knew how to do it. She had the keys. Got mad and he pushed me down. And then that's when an altercation happened in the garage. He kicked me in the head. And then, I crawled to get my phone out of my purse and he grabbed my phone and he slammed it on the ground and he said, "Are you gonna call your mommy?"
And let me stop you there. During the events you just described, did that cause you pain?
Yeah.
Was the defendant aware of what he was doing, or was it an accident? And what happened next?
So then he threw my purse and everything in the living room, I'm sorry, in the front yard. And then, he went into the house and grabbed my puppy. And I was sitting there in front of my car. He opened the front door and he had my dog in his hand. So I went to go in to the house to get her. That's when he hit me in the nose. My nose was busted. And then he pushed me down and he did drag me by my hair. And then, I crawled to the room. She went underneath a bedroom, underneath the bed in her bedroom, and I grabbed her and I ran to the neighbor's house.
And did you have any bruises or bleeding from the altercation?
Yes, my nose was bleeding. You can see in all the pictures, my eyes were.
Judge, may I approach?
Yes, you may.
Ms. Lewis, I'm going to show you what's marked as State's Exhibits 1 through 8. If you wouldn't mind taking a look through these photographs. We'll start with Exhibit 1. If you could describe to the jury what you see in this photograph, any injuries that you see.
A few hours later, but the nose and the bruise and cheek.
We'll look at 2 and 3. Do you see similar injuries in these photos?
Yeah.
Do you see bruising in these photos?
All starting.
And we'll talk about Exhibits 4 and 5. Do you see bruising in these photos? Let's talk about Exhibits 6 and 7. What is this a photo of? And do you see bruising in these photos? And finally, let's talk about Exhibit 8. Can you explain for the jury what Exhibit 8 is?
That is my friend. Verified document.
And that's your leg? When all this was taking place, Ms. Lewis, were you afraid? And was this the first time that anything like this had happened between you two?
Object, Your Honor. May we approach?
Ladies and gentlemen, the jury is going to ask that you would follow the bailiffs to have a step outside in the hallway, and we'll call you back in. Okay, Mr. Bailey and Ms. Maxey?
Yes, Judge.
Okay. Now, Mr. Bailey, you can state on the record.
Yes, Your Honor, I'm objecting to any inference or any testimony regarding past instances of alleged assault in this case. It goes to show, it could potentially show conformity therewith. It's against the rules of evidence, and that's our objection.
Ms. Maxey?
Yes, Judge, the Code of Criminal Procedure, Section 38.371, specifically allows for this sort of information to be brought in these sort of cases. Any evidence to the nature of the relationship between the alleged actor and the victim.
You say 38?
38.371
That's 38.371?
of the Code of Criminal Procedure.
Evidence in prosecution of offense committed against the defendant and all household person in the damages.
This is as evidence of his character.
I think that you're skating a very thin line.
Well, that's what the judge said. The evidence goes to the nature of the relationship, not his character.
Okay. In reading this statute, Article 38.371, this statute, as it says, this change in the law, the change in the law made by the act applies to the admissibility of evidence in a criminal proceeding that commences on or after the effective date of the act. And the effective date of the act was September 1st of 2019. This offense occurred February 24th of 2019, which is before, and it says the admissibility of evidence in a criminal proceeding that commences before the effective date of the act is governed by the law in effect on the date the proceeding commenced and the former law is continued in effect for that purpose. So what was the law prior to September 1st of 2019?
The law prior to September 1st of 2019 actually specifically listed Penal Code Section 2201 as being included in the statute. I can pull up a copy of.
Okay, well, that's what I need to see because the law, let's see if I have, hold on, I may have. my own book. This is the old statute, 38. Oh, yeah.
You have an old one, Judge?
Yes. Okay, I'll read the statute that was in effect at the time. It says Article 38.371, evidence in prosecution of certain offenses involving family violence. And under section, well, I'll just read the article. It says, this article applies to a proceeding in the prosecution of a defendant for an offense or for an attempt of, or conspiracy to commit an offense that is committed under, and then one says section 22.01 or 22.02 of the Texas of the Penal Code against a person whose relationship to or association with the defendant is described by section 71.0021 subsection B or 71.003 or 71.005 of the Family Code, or two, section 25.07 or 25.072 Penal Code if the offense is based on a violation of an order of condition of bond in a case involving family violence. Okay. Now B states, in the prosecution of the offense described by subsection A, subject to the Texas rules of evidence or other applicable law, each party may offer testimony or other evidence of all relevant facts and circumstances that would assist the trier of fact in determining whether the actor committed the offense described by section A, including testimony or evidence regarding the nature of the relationship between the actor or the alleged victim. C, the article does not permit the presentation of character evidence that would otherwise be inadmissible under the Texas rules of evidence or other applicable law. So the question is whether or not you are presenting evidence or you're presenting character evidence that would otherwise be inadmissible.
Judge, this evidence goes to the nature of their relationship with the jury, not to the defendant's character.
Okay, Mr. Bailey.
Well, Your Honor, first and foremost, what evidence are you attempting to introduce? You're asking about prior bad acts, right? Prior instances of assault in this relationship, right? So if the nature, if you want to say, was it an abusive relationship, maybe that's the nature, but for you to say, where is this not the first time? And then you go into previous times and give specific dates, it's exactly that. It goes to, it's character evidence. It's showing that the conformity of, that my client is aggressive, that he was aggressive before, he's aggressive now. It's character evidence. They're given specific instances. And I haven't been provided any previous statements about specific instances or pictures. So, and I don't know where she's going to go with this, but I mean, if it's introduced, I'm going to ask for a mistrial.
Okay, Ms. Maxey.
Judge, it's not as important to go into specific instances as it is to show that this was something that had happened before, and this was not the first time. So going into specific bad acts that you're talking about, that's not my goal here.
And my concern is that so that's a very narrow line to especially when we're talking about the nature. So we're here for an assault, right? And so if she's going to introduce testimony of previous assaults, it conflates the issue and it confuses the jury. I don't think it's relevant. I think that it's highly prejudicial. And I think that it is against the rules of evidence. Especially if what is it, 38.371. And we're using the previous law, correct? Not the current. So this is never something that is allowed to come in if we don't open the door. And I don't think that it's highly prejudicial. It's unfairly prejudicial. It's not relevant, and it's against the rules of evidence.
Judge, I would just argue that the existence of this statute is exactly for the purpose that we're asking for, to bring this evidence into a family violence case.
And I would just say, Your Honor, we're here for the incidents that occurred allegedly.
Okay, well, first of all, we don't know what the evidence is because it hasn't been brought up, but the court will rule this way. The court would allow testimony or other evidence of all relevant facts and circumstances that would assist the trier of fact in determining whether the actor committed the offense, including testimony or evidence regarding the nature of the relationship between the actor and the alleged victim. However, the court will not permit the presentation of character evidence that would otherwise be inadmissible under the Texas rules of evidence or other applicable law. Okay, so you cannot bring in any character evidence, present any character evidence that would otherwise be inadmissible under the Texas rules of evidence or other applicable law. Okay, so that's the ruling of the court. Okay, now you may be seated. At this time, you can bring the jury back in.
Your Honor, just so we're clear. So when the jury comes back in, I understand the ruling. I think that there's going to be an issue with an argument about what's considered character evidence and what's not.
If that happens, I mean, she's not allowed to get into character evidence. And you stated
Your Honor, and one other thing, the whole purpose of that statute is it was to rebut the defense's theories of victim fabrication, recanting, and failure to appear. That's none about that. That has nothing to do with what we're alleging. We haven't even alleged a defense at this point.
now, what rule you cited in reference to the character evidence, Mr. Bailey?
let me. I just said it was against the rules of evidence. Is it 609 or 608?
608 deals with a witness's character for the truthfulness or untruthfulness.
It's conformity therewith.
At this point, there's no witness that is being attacked.
Yeah, no, it's the issue is it goes to conformity. It's against the rules of evidence to introduce prior bad acts that would show conformity therewith.
Are you talking about rule 404?
No, that's why, I mean, I brought up that objection too.
Yeah,
No,
because
it's-
rule 404,
Yeah, it is rule 404.
yeah, but there's an exception to that rule. Yeah, crimes or wrongs. Yes, it's rule 404, character evidence, crimes or other wrongs. Exceptions for accused in a criminal proceeding may offer evidence of the defendant's pertinent trait if the evidence is committed. The prosecutor may offer evidence to rebut it. That's what you're citing. Exception for vision. No criminal except for limitation rule for defendant may offer evidence of victim's pertinent. No, trait. Okay. Exceptions for witness evidence. Crimes or other wrongs, prohibited uses. Evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that the particular occasion that the act, okay. This is what, it's rule 404B. Crimes, wrongs, or other acts. One, prohibited uses, evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that a particular occasion the person acted in accordance with that character. So if
There's one massive thing that I missed. There was no notice that they were going to use extrinsic evidence, and I requested, and there was no notice given.
Again, Your Honor, this is not evidence to be offered as character evidence. This is evidence entered or asked to be entered under 38.371 to show the jury the nature of the relationship.
which is admissible, but if it is character evidence, then it will be inadmissible under rule 404B. So as the court has already ruled, you're allowed to bring in evidence under 38.371. Yeah, 371. However, you're not permitted to present any character evidence that would otherwise be inadmissible under the Texas rules of evidence. So if you're trying to get in evidence that is inadmissible under 404B or any other rule, then that will not be permitted. So at this point, the court does not, and nor does the defendant, I guess. The defense knows exactly what is being brought up. But the court is informing you that if you're going to get into any character evidence, you need to approach the court on that, because the court is not, first of all, the court is not going to allow you to get into it because it's not permissible by the rules.
Yes, Judge.
Okay. All right. All right, so we're ready to go forward. You can bring the jury in. Yep. You may be seated. Let the record reflect that the jury is back in the courtroom. At this time, I think Ms. Maxey, it was your witness. You may proceed.
Thank you, Your Honor. Ms. Lewis. Can you speak a little bit to the nature of your relationship with the defendant?
It was perfect in the first month. A lot of love bombing that I now know is love bombing, but everything seemed really perfect. We got along really well. I fell in love with his daughter.
Let me stop you. What is love bombing?
Over bombarding you with love, affection, gifts, attention. And then I fell in love with his daughter. And about a month after we got together, that's when the first incident happened. Where my nose was,
Honor, just for the record, I'm going to object to anything that goes into, well, I apologize. I withdraw my statement.
Okay. You may proceed.
so about a month into it, that's whenever he turned into a completely different person. My nose was busted. And that is also whenever he strangled me for the first time. He kicked me in the head with boots. And then went to go drink more.
Let me ask, did you ever get violent with the defendant?
I pushed his cheek like this one time. Never again after that.
So it's only that one time
Yes.
during the course of your 3-year relationship. Let's go back to the night in question. You recall the events that happened that night. You said you went to a neighbor's house, correct?
The last event.
And did you call the police when you got to the neighbor's house?
No, I called my cousin to come get me.
Okay.
As soon as we got to her house, a domestic violence advocate met me there. And she told me basically how to go about why I needed to go to the police and why it needed to be on record. And then, so we called the police department. They met at my grandparents' house, my papa's house in Walmart, and took the statement.
And who was with you during that time after you left? You said you went to your cousin's house.
Yes.
And who was with you during that period of time between leaving the scene and meeting the police?
My cousin and my aunt. And then I believe my mom met after she lived in Houston. She's who I originally called, but my cousin was in Silsbee, so it's closer for her to come get me from the neighbor's house.
And when you met with the police, did you also get checked out by an EMT or did you go to the hospital?
Yes, and
An EMT. And what happened once you had given the police a statement? What happened next?
they took me to his house to unlock my car, get my keys, and they took me in the house to get, I just needed to, they only let me get my laptop, they said leave everything else. I picked up all my stuff in the front.
Are you two still in a relationship?
No.
When did that relationship end?
That day.
The day of the incident? Did you have any permanent impacts from the incident in question? What were they?
So much anxiety and depression, PTSD, emotional trauma.
Did you have any physical impacts?
Yes, my nose. I've had a bump on my head, my back of my head and front of my head for probably a month and a half after.
Judge, I'd ask to publish the photos to the jury.
Okay, we have to give each one of the jurors a set of gloves. Let's do that first.
That's the witness, Your Honor.
You ready to proceed after they see the
Yes, Your Honor.
photos?
I'm gonna
Okay,
give them some time for it.
okay. Okay, she's finished. You can just set them up. That's fine. Mr. Bailey, you ready to proceed?
Good afternoon, Ms. Lewis.
Mr. Bailey, are you gonna go to the podium or are you gonna stay there? Either you, it's your choice.
Sorry. Good afternoon. We're here today for events that occurred on or about February 24th of 2019, right?
Yeah.
And anything that had to do with 2019, we're not here for that, are we?
What actually?
Are we, answer my question, yes or no. Are we here for prior acts that you allege to have happened before February 24th of 2019? No. And just briefly, before we get into what occurred on the purpose for why we're here, let's talk about what you said in the past. Whenever police report filed, did you ever file a police report for anything that you have already alleged that occurred before the date of February 24th? No. And, okay, let's move on past that. Where did you live on the date of February 24th of 2019?
I had an apartment, but I was living about 75% at his house.
So you were living at his house or were you living in your apartment?
I was at his house more than I stayed at my apartment maybe 2 or 3 nights a week. I was at his house
And where did you work?
in Kingwood.
Okay, and where is his house located?
What'd you say?
Kingwood,
Okay.
Walmart.
Okay, so you worked in Kingwood, but you lived in Beaumont with Ben? Okay,
Well, I got the job about a couple months before we broke up, so,
okay.
or he was at my apartment with me.
Let's talk about the events that occurred on February 24th of 2019. And I kind of was hard to understand. Let's talk it through it stage by stage. So what occurred on February 24th of 2019?
We went out to eat and got back to the house. He was driving his dirt bike around the neighborhood. Whenever he pulled it back into the garage, I remember it hurt my leg. I went to go to my car, realized the car was locked. Asked him to open it and he wouldn't. He pushed me down. This is all broad daylight.
But at what time of day was this?
Probably 1 or 2, maybe, is when it started.
Okay, and how long did it last?
Only about 30 minutes.
Okay. Continue on.
Arguing, so bad.
Sorry to interrupt you. Yeah, just tell us from the moment we stopped what happened.
They pushed me down, in the garage, and then it opened my car door.
You said he kicked you in the head, right?
Yes.
More than once.
He kicked me, yes.
So he pushed you down,
Mhm.
he kicked you in the head, and he punched you in the face, right?
He hit me in the face whenever I was going to the front.
Okay, so did he punch you in the face? Okay, earlier you said something about your nose. Did you have a broken nose?
Whenever I was going to get my dog from him.
Okay, and was your nose broken? You had a broken nose. All right, and so it happened, you said 1:32 during the day? Okay,
It's after, yeah,
who came and picked you up?
my cousin.
At what time of the day was this?
It took her about 30 minutes from the time I called her to get there. I was waiting at the neighbors. It was about the exact time that he was packing up to go to work.
Okay, so I'm just trying to timeline it for the jury. So it began at 1:30, you left that house, the neighbor's house about what, 2:30? Give or take?
It was a very traumatic situation. I wasn't looking at the clock. He busted my phone. I honestly don't know what time it was, but I do know that by the time I was leaving the neighbor's house, he was packing his truck up to leave for work. So whatever time he usually left for work.
Okay, and when you left that area, you went to Hardin County, correct?
Correct.
Okay, and you didn't call 911, did you?
I met with a domestic violence advocate.
Okay, and what did you do from there?
Then we went to Jefferson County and that's whenever the police came and spoke with him.
Okay, so you went from Beaumont
Mhm.
to Hardin,
Yeah.
then back to Beaumont to meet the police.
I never wanted the police involved because I never wanted them to get in trouble.
Okay,
I was
but
terrified
how did the police get involved?
because the domestic violence advocate was there. They called her there to speak with me and tell me how big of a situation this is. And if I didn't get out, if I didn't call the cops, I'd probably be back
Okay,
and it would be even worse than the first time.
and do you know about, if I told you that those photographs were taken about 9 o'clock at night, would that sound about right? So the photographs were taken some 6 hours after, or 7 hours after the alleged event occurred. Is that about accurate?
By the time we gave my report, spoke with everyone, went from waiting at the neighbor's house, all the way to talk to the domestic violence advocate, and back to the police.
Okay, and you said that it was so bad that you had to crawl to the neighbors, isn't that right? Okay, and when you crawled to the neighbors, you didn't call 911, did you?
No.
You
All
didn't,
my family.
okay, and no one else, the neighbor didn't call 911, no 911 call was placed, right?
She's been in that situation before, she understands.
Okay,
I didn't say anything other than, can I use your phone? She opened the door and let me sit in her living room.
okay, and so you didn't call the police though, who did you call? You said your cousin? Okay. And, later that evening, you said that EMS showed up and they checked you out, isn't that right?
Ambulance and, the police came.
Okay, and they didn't take you to the hospital, did they?
No, so it's fine.
And no one diagnosed you with a broken nose, did they? No. In fact, isn't it true that the first time you talked about your nose being broken is today?
No.
Prior to today, you never said that your nose, sorry. Prior to today, you told the police, or was there a diagnosis that your nose had in fact been broken?
He has busted it, that was the third time he's busted or
Okay.
broken my nose.
And so your nose has been broken 3 times. Okay, and the past 2 times, did you call the police or was there a police report filed? And in fact, one time, did you call the police and did the police show up and then they didn't arrest him? They told you it was your fault and they left?
No, the police were called and they were banging on the door and I didn't answer because that's how narcissistic relationships work.
How did
And
that?
then another time, I was moving my
Let's-
stuff out.
And I apologize. I don't mean to interrupt you. I want to stay on topic. We're talking about the 2 times prior that you said your nose had been broken.
Yes,
And that's why I brought up if you had called the police and you said no.
yeah, because of the circumstances of the relationship.
Okay, but on the date in question, no one diagnosed you with a broken nose. And did you ever go to the doctor after the fact for a broken nose?
No,
Okay, so how do you know your nose was broken?
okay. I cannot know for a fact what it was broken, but he did hit me in the nose. It's crooked. You can see that
Um,
either way he hit me.
and it's your testimony today that you never had any you never got violent with Mr. Steele?
One time,
Okay,
and I literally just pushed his face.
all right, so just to recap the timeline, this alleged event occurred at 2 o'clock on February 24th, right?
About,
Okay, you left Beaumont, went to Hardin, correct? Then went from Hardin back to Beaumont to your grandparents' house, right? And then the police came some 6 hours after the fact, is that correct?
no, please not there.
Okay, about what time do you remember did the police meet you there?
I still didn't have a phone. I was in, I can't tell you the exact moment. But I know that whenever we went to his house and they let me in, it was dark.
Okay, and you had access to a phone, you used the phone at the neighbor's house, right? And your
Yeah.
cousin picked you up, right?
But I wasn't keeping up with the time. It wasn't that long.
And we can move on. Just also to recap, you alleged that he kicked you in the back of the head, right?
Yes.
That he pushed you down twice, right? That he burned your leg, right? And that he broke your nose. Can I see?
There's no there.
May I approach your honor?
Yes, ma'am.
I'm now showing
Does she,
the,
does she have gloves on?
I'm not, it shouldn't have a touch, I'm just gonna put it on.
Okay.
I'm showing the witness what's been marked as states exhibit number 1. In this picture, you're alleging that your nose is broken, right? And in this picture was taken some 5 or 6 hours after the alleged event occurred, right? And this picture was taken by Yes, while EMS was there, correct? And
Could you speak up a little bit?
while EMS was present, correct?
Yes,
And did anyone diagnose you or even check your nose out? Did anyone diagnose you with a broken nose?
they looked at all of my concerns. She took pictures. She asked if I wanted to go to the hospital. I said no.
Okay,
That's
and
whenever they escorted me.
when you got to his house, what did you take from the house?
I took my laptop and my purse.
Okay, and wasn't it your testimony earlier that you basically lived with him 75% of the time?
Yes, they said to leave it, everything, and it's on his record from his wife and then.
Okay. And so you expect the jury to believe your testimony today that you had a broken nose, that your boyfriend at the time, Mr. Steele, punched you in the face, broke your nose, pushed you down, kicked you in the back of the head, and burned your leg. Do you feel at all that you're over exaggerating or maybe fabricating? No. All right, that's what it is.
Ms. Maxey?
Ms. Lewis, earlier that day, had y'all been having a nice time?
Yeah, normal. Yeah. Normal day, he said, if you have to work, we then,
And so once you got home, the switch flipped?
yeah.
Mr. Bailey talked a little bit about the instances that happened before. Why didn't you file a police report any other time?
Mostly within denial. I didn't want anybody to know. And, I didn't want him to get in trouble. He was on probation for like the first.
Objection, Your Honor. Well, I'm objecting to strike, sorry. Continue.
Okay.
Sorry.
May-
Just leave out any.
I didn't want him to get in trouble. I didn't want anybody to know I was in that type of relationship, after the first time. It got harder to talk to my family about anything, so I didn't want to tell anybody. I didn't want to be away from Brooklyn, his daughter. And I acted like everything was normal because I was manipulated into thinking that it may have been my fault, or after any incident would happen, he would just act like nothing happened at all, and it would just make me question my sanity.
Is that why you stayed in that relationship for so long? The night that Mr. Bailey was talking about where the police were called, did you, you didn't make a statement with the police, is that correct? You did not make a statement with the police.
I believe he's speaking about a time where he was putting all my stuff in the front yard, throwing all my stuff out. This has nothing to do with any encounter. He was throwing my stuff in the front yard, so my family came and he called the cops because they were on his yard getting my stuff that he was throwing out. And they did tell my family to not step on the yard.
And you didn't call the police during prior incidents, but you did take photos, didn't you? You take photos every time?
I took a lot of photos that a lot of our first half of our relationship were deleted by him. All of our text messages, anything that was really negative or anything like that, but I did save pictures from the very first time.
That's a witness, right?
Ms. Bailey?
Just a few. How long were you and Mr. Steele together?
About 3 years.
And this, so from like 16 to 19? And the last time that you guys separated or broke up on this date, the 24th or 25th of 2019? Do you still maintain contact with his daughter?
Yes,
I'm gonna object to the relevance, Your Honor.
she's my family, we're related.
Miss, just hold on. Objection, sustained.
Pass the witness.
Okay. Ms. Maxey, you have any further questions?
Nothing further, Your Honor.
And Mr. Bailey? Nothing further?
Yes, no, nothing further about it. I would ask that she be.
Okay, now, Ms. Lewis, the rule has been invoked. And what that means is that you are ordered to leave the courtroom and do not re-enter unless instructed to do so by the bailiff or the judge. And you are not to discuss the case or your testimony with other witnesses or anyone else except the attorney. Do you understand?
Yes, sir.
Okay, and we also ask that you do not read any newspaper articles or anything of that nature relating to the case, okay? So you're under the rules, so please do not talk to anyone about your case except the attorneys. And at this time, we're gonna ask that you step down. May she be excused or,
As far as the state's concerned, she may be excused.
Mr. Bailey?
Yes, Your Honor.
Okay, you may be excused. And you have a blessed day. Okay. Okay, ladies and gentlemen of the jury, there are some matters that needs to be taken place, that needs to take place in court. And so at this time, we will be in recess. Now, I know that we started before lunch, and I don't know if you had an opportunity to get lunch. So if you haven't had an opportunity to get lunch, you can get lunch. And we'll ask that you be back at about say 3 o'clock. Okay? And just follow the bailiff. We'll be in recess. Is it reference to a case on the docket?
It's from this morning, it's on the announcement. Yeah, like, on.
Oh, which, hold on a minute.
And I had it last one.
Let me get my docket. Okay, who's the gentleman? Who's your client? What's his name?
Trends in TRINSEY.
Oh, that's the gentleman. Okay, we're just gonna try to get him on.
I
Mr.
got it.
Trenzy, would you please come forward?
Yes. Come on up.
Okay. You can take your time, Mr. Trenzy. Okay, okay, now, Mr. Kimler,
Trenzy.
no, I'm talking to him.
Okay. Oh, I'm sorry.
Yeah, Mr. Kimler, you have an announcement you'd like to make,
We'd
Mr.
ask to be
Trenzy?
put on the trial docket, John.
Okay, we're gonna reset it for,
Mr. Trends.
Nathan, Nathaniel Trenzy, page 3 of the trial docket. Oh, no, not of the announcement docket.
Can you give me the case?
I'm present.
The cause number?
Yes, sir.
328274.
This one case,
Yes,
January 10th.
okay, case gonna be reset to January 10th. You can get your reset. Stand over there with your attorney. Once you get your reset from your attorney, you'll be free to go, Mr. Trenzy.
I'm glad to meet you.
And nice meeting you as well. And you have a blessed day. And you have a blessed day as well, Mr. Kimber.
Thank you, John.
Okay, we'll be in recess.